is how to stay compliant with rules and regulations of healthcare. Our presenter today is Adrian Senyszyn. Adrian is a partner with the Germer Law Firm out of the San Antonio office and is uh, has been very helpful to many different practices across the state, but more specifically, has helped many practices that have had cyber incidents go through the post incident investigation, mitigation, and even OCR investigations. Our objectives for today are to identify the healthcare rules and regulations that have a great impact on your practice, discuss how failure to comply with these rules and regulations can affect your practice and potentially your career, and to list how to improve your current processes, um, and that how that can help improve your compliance. Adrian, I believe you need to share your video. I'm not seeing you on camera. There you are. It's my pleasure at this time to turn the presentation over to Adrian Senyszyn. Thanks, Adrian.
Thank you very much, Cathy, and I'd like to thank TMLT for inviting me to speak today. And I also want to recognize the wonderful TMLT employees and staff who helped make this presentation a success. There was a lot of effort put into the presentation, vetting, and contribution from everyone behind the scenes. So I want to thank them. It looks like we have a terrific group of participants today, so I'm excited to run through a presentation that briefly touches on some of the administrative agencies who are in charge of privacy and security. We're also going to discuss some of the medical record consents and authorizations and what is the difference between a consent and an authorization. There's some confusion there in terms of releasing healthcare information and then also releasing written healthcare information in the form of medical records to persons, patients, and entities. And then last, we'll also talk about a business associates agreement, and then last we'll touch on some of the cyber issues affecting practices. So the Office of Civil Rights really is the agency in charge of policing HIPAA. Other agencies within the state include the Texas Medical Board and the Texas Attorney General's Office. These agencies, the Texas Medical Board and the Attorney General's Office, typically do not get involved to the extent that the Office of Civil Rights does. Unless there's a complaint made to the Texas Medical Board, they might investigate a HIPAA complaint if it rises to a certain standard. Up until today, I haven't seen any real major investigations from the Texas Attorney General's Office investigating HIPAA violations. Not to say that some haven't occurred, but they don't investigate HIPAA issues as much as the Office of Civil Rights. In addition to HIPAA issues, the Office of Civil Rights also investigates discrimination and then patient safety, and they encourage voluntary reports of medical errors. The mission of the Office of Civil Rights, which is part of the U.S. Department of Health and Human Services, is to investigate complaints, conduct compliance reviews, provide corrective and remedial action. They put out policy, and then they provide technical assistance. So what they're really doing is they're putting out policy about regulations that have been passed in acts by Congress, and then they provide education through their website and other directives on that guidance. They also help create rules and interpretations of those legislative rules. And then there's an enforcement arm where they will come in and investigate a practice who may have some sort of complaint, whether it's discrimination, uh, privacy, or a security complaint. And then, as part of that investigation, they may provide what they call technical assistance. Again, this relates back to trying to get the practice to correct what it's doing wrong. I would say this through my experience dealing with the OCR, their primary interest is to effectuate some sort of change so the practice realizes what they've done wrong and has corrected it. They're not as much interested in finding and penalizing a practice unless the practice is just blatantly disregarding um, the rules that have been put in place, or refusing to put in place corrective action. The compliance issues most investigated as of the first quarter of this year were impermissible uses and disclosures of health information. That would be, potentially a lack of authorization. You could have a breach associated with that. So, a hacking incident. Those are examples of impermissible uses and disclosures. Lack of safeguards of protected health information. And there's really three key categories there. There are administrative safeguards, technical safeguards, and physical safeguards. Administrative safeguards, which is referenced in number 4, really make up half of the rules promulgated. And those are rules about how you document, what kind of policies and procedures you put in place, your business associate agreement, your security officer, and how those rules are implemented internally. Technical safeguards really relate to your technology, right? Your data. What are you doing to protect it when it's at rest, in transit? How are you dealing with issues when you might have some sort of incident affected to that information? And then physical safeguards, really, it's really how are you protecting your physical equipment, office space, and written equipment, and people who have this privacy information in the physical location. And then the last compliance issue really is use or disclosure of more than the minimum necessary PHI. So that goes to the issue of, releasing information, whether it's through a consent or an authorization. So what's this issue of consent and authorization? And I know this is a big issue for TMLT, and I think this is a good stopping point for Cassie to jump in and just talk about some of the issues facing TMLT insureds.
Sure. Thanks, Adrian. We do in our risk management department get quite a few questions about the difference between consent and authorization. And we don't want to get too far into the weeds because we know that it can be complex, but just high level, the privacy rule allows you to obtain consent for treatment payment healthcare operations if you so choose. I think the big takeaway, if you choose to do that, is to have a written policy and procedure stating what your process is and to be consistent with that process that you're utilizing across the board for all your patients. Authorization, on the other hand, is very detailed. It's very explicitly explained if you go to the HHS website what they want to see in an authorization, and that is required for uses or disclosures of protected health information that fall outside of traditionally treatment payment and operations. So, for example, treatment to a third party for marketing purposes, for research, treatment for substance abuse disorders, and obviously psychotherapy notes would fall into needing an authorization over a consent. So again, a very high level, but just some context of the difference between consent, which is a permissible, and authorization, which is more required if you're falling outside of that TP&O, as we call it.
And on a real basic level, I mean, you don't necessarily need a patient's consent to, for example, operate your practice and share information within your practice, share information with the business associate, as long as you have documented policies and procedures in place and a business associate agreement that describes and helps you enforce how that information is shared. So that would be an example of that sharing within the office. Outside of the office, what we're really a lot of times getting questions on is that written authorization and when can we release medical records to other people or entities, or unique situations that fall outside the traditional information sharing. And we'll look at a few of those in this presentation. So some of the scenarios that we've come up against is, does the HIPAA privacy rule permit a doctor to discuss patients' health status, treatment, or payment arrangements with family and friends? Can covered entities leave messages for patients on answering machines? And the third one is, sorry about the typo there, it's can covered entities leave messages for patients with their families or friends? Okay. And with regard to the first question, just the general overall communication with the patient about patient and their friends or relatives about a patient's health status. Yes, generally, if the patient agrees or does not object and it's relevant to the patient's healthcare. So some examples are if family members are present when a patient is going into surgery, it's absolutely appropriate for a surgeon to come out into the waiting room and discuss how the surgery went with that group of family members. Likewise, if a roommate, in college, if a roommate brings their roommate to a physician or to the emergency room for a break, if they leave, well, the physician needs to give that person who's taking care of the individual some instruction. So in that instance, it's okay. The physician can communicate that information. It's obvious that the patient doesn't object and they've consented to that person being there and learning about their healthcare. Another example, this is outside of the ones that are in your slides, which you'll get a copy of your slide deck. And I had this just come up last week with the practice. We had a mother and a daughter who came in for an OB-GYN visit, and the mother was calling and asking for lab information, and she was also asking for a physician switch within the practice because they weren't happy with what occurred. And then subsequently, 2 months down the line, the patient called and revoked the authorization, or I guess her consent to release information to her mother. So that brings up an issue. As long as the patient is consenting and not objecting to the information being released to the family member or friend, then it's okay to release that specific information, obviously using professional judgment, as long as the patient doesn't object and as long as it's relevant to the treatment that was being given. So you can't just start releasing information about the patient's whole health care over a 2-year period of time. It has to be related to that specific treatment. And it also has to be related to why that family member or friend is involved. So those are the limiting factors. Can we leave messages for patients on answering machines? Yes, but you should take care to limit the amount of information that's disclosed. And if the patient says they don't want to, they wouldn't like to receive any sort of information on their answering machine, then the practice shouldn't call and leave information on the answering machine if it's at the patient request. Similarly, for patients, leaving messages for patients with family members or friends at a location, yes, if you're using professional judgment and you decide it's in the best interest of the patient to provide that information, and the information is being limited. Okay. Again, this is going to be a professional judgment call where if you feel that the consent has been provided to leave this kind of information with a family member or a friend, then you can go ahead and do that. And you want to be sure to limit the information. However, again, if the patient says, I don't want that information to be disclosed to family or friends, or the fact that I came here, then you can't call and leave that message. The patients do have a right to direct their PHI to another person. I think the key takeaway in this slide is, and this will kind of transition to written authorizations, whenever that patient directs their PHI to be released to another person or entity, you need to get it in writing. It needs to be signed and dated by the patient. It should identify the person or entity to whom the information is going. And it should also have some sort of discussion about the scope of the information being transmitted. So again, we're getting very close to a written authorization, and that's really in a lot of ways what this is. Can a patient electronically sign and date a request like this? Absolutely. You can, I think electronic signatures and dated signatures are generally accepted at this point in time. So what happens, this question comes up from time to time, what happens if the patient is incapacitated and we don't have consent? Well, the covered entity or the physician or the surgeon, this is an emergency situation in many instances. They can typically share information about an individual to a spouse or a family member when they're exercising professional judgment, when it's determined that it would be in the best interest of the patient. So again, a surgeon would have the ability to share information if a patient has a heart attack or a stroke with a spouse or a family member. And this just makes sense, right? I mean, you want the people who care about the individual to be involved in the healthcare and treatment of that individual in emergency situations. And also you want to be looking for the individual within that group who probably has the most to say about that healthcare and treatment. So we're trying to identify who are those individuals. Questions probably are routinely asked. Does anyone have a medical power of attorney? Is there a spouse? You'll start with a spouse and then you'll work down the family. But it's okay to communicate with family members in those instances. But again, the key here is best interest of the patient and exercising professional judgment. So how important is it to document the rationale of our professional judgment and this concept of it being in the best interest of the patient? Well, it's really important to do that. I don't think it gets done routinely, and it could be as easy as just documenting in the chart that made contact with family member who was a brother who was involved, who knew the individual who was incapacitated very well, and felt due to the nature of the injury and the emergency, important to share and communicate with that individual the status of the patient, right? So we've identified the treatment that was, or the information that was communicated. We've limited it to the status of the individual. We've made a quick note, and we've also used some of that key language, best interest, and it makes sense. This is something that's intuitive, but it's nice to document, right? It's also nice for nurses to not document when they see a patient or witness something like this, to document that, family members were present, understood. This was in the best interest of the patient to communicate that information. So when we talk about authorizations, I think all of us understand we have these written authorizations for the release of medical records in particular, and you can't release medical records without an authorization in writing. the elements for valid authorization are: they need to be in writing, they need to be signed and dated by either a patient or a personal representative, parent or legal guardian, attorney ad litem. And this is kind of a brief list of just that order it could be in. So the patient, and then you have parent and legal guardians if they're incapacitated, attorney ad litems, or personal representative, which we have in a different slide a little bit later on, is really incapacitated or deceased individuals. I'm sorry, deceased. So you're dealing with an estate. And then it needs to specify the information sought, medical, billing, or other, the reason or purpose for the release, and to whom the information is to be released. Now, if they only ask for records related to a certain period of time and everything else is valid about the authorization, then you only release the records related to the period of time or the scope that's requested. Likewise, if they only request billing records, that's all you release. The authorization does not allow you to go beyond release of billing records in that case. So just be careful that your staff or whoever's working on the medical record release, they stay within the scope of the requested information. Practices have 3 weeks, 15 business days to release information, but you might need to release medical information and medical records more quickly in an emergency situation, or if a patient's making an access request. A big emphasis of the Office of Civil Rights is access requests for the patients. There have been several significant fines and penalties issued by the Office of Civil Rights for a hospital or a medical practice's failure to promptly release medical records either to a patient or where the patient is directing them. So it's a really good practice if you release medical records, one, as soon as you reasonably can to any person or entity, as long as you have a valid authorization. But two, if the patient is specifically requesting the information, that should be brought. Your medical staff should be trained to try to get that information to the patient as soon as possible. And obviously, if it's an emergency situation, you need to get that information out as soon as possible. So can consent be withdrawn? Yes, and practices are absolutely not on the hook for any information that was disclosed before a consent or an authorization was withdrawn. You certainly, the preferred method of a withdrawn consent is to have that information documented in writing. So perhaps the patient is changing an authorization that you have within your medical practice that removes someone from who would be otherwise authorized to receive healthcare information. A great example of this is a spouse or a boyfriend or girlfriend. When individuals get divorced or have a breakup, sometimes those authorizations need to change. And sometimes they don't change until after the person discovers that their ex-spouse or person that they're going through a divorce with had access to their medical records and was authorized to receive them. So the practice is not on the hook for information that was released subject to a valid authorization. Same in the scenario that we had discussed earlier with the practice with the mother and daughter who provided consent and the mother who had been involved in the healthcare of that patient. Once that consent was revoked, in that instance, the practice documented that in the chart that the consent was revoked, and they also notified individuals involved in that patient's care and trained them. So they were everyone involved knew. They put some special documentation within the chart, which would call attention so the mistake wouldn't be made by a subsequent nurse or employee releasing that information to the mother. So this is back to the decedent. Does does the privacy rule allow an entity to disclose healthcare information about a decedent to family members and other persons involved in the care? And the answer again is yes, if that family member or person was involved in the healthcare or treatment of that individual, and that consent or authorization had not been revoked. And you want to be careful to limit the information that would be relevant to the decedent's healthcare treatment that family member was involved in. So you're generally not going to share information about past healthcare or events that are unrelated. And if that family member is asking for medical records related to the decedent, now your antenna should go up. They're asking for a written medical record. Well, they're not allowed to have that without a written authorization. And with the decedent, you need to have a written authorization from a personal representative of the estate. So the practice should be insisting on a personal representative who's authorized to sign the authorization, providing it. One of the great ways to verify this is if there's a will and a person is appointed the executor of the estate, they will receive a document called letters testamentary, and they certainly can furnish a copy of those, providing them with the power to administer the details of the estate, which gives you the comfort of knowing that that person who's presenting the authorization to use the personal representative. Is a valid authorization required for the release of a decedent's healthcare record? We just talked about this, but absolutely. You have to have a personal representative signing that authorization. Okay. Let's go back to a different scenario or a different hypothetical. If it's not a deceased patient, but maybe it's a person who has a mental capacity challenge, and they're not competent to manage their life or their health care. In that instance, you will want to see, and you certainly can make a copy of, the legal guardian's authorization to manage that ward's healthcare in order to be able to release the medical records. It could be a legal guardian. It could be an attorney ad litem. I don't think in a lot of instances in that case, the person who brings the ward or the mentally challenged person to the practice for the first time is going to be that same person, right? And it's going to be made clear when they first present. How much can a practice charge for medical records to a person or entity other than the patient? We need to be really careful here to distinguish that this is a charge to other persons or entities. So this statutory charge does not apply to a charge to the patient. It's to other persons or entities. And it's a statutory rate. It's all in, this is the current statutory charge. So when you get the slide, you'll be able to review the rates, and it's located in the administrative code. There's also a flat fee that practices can charge. If they don't want to worry about calculating those administrative rates, they could just charge $650, inclusive of all labor, supplies, postage, and that would cover, that's presumed reasonable. That's a rate put out by the U.S. Department of Health and Human Services as a rate that's presumed reasonable for the release of records. Now that rate, you can't charge for other administrative costs, so you can't tack on charges. It's just a flat $650. So if you wanted to follow the Texas rule, you can charge $25 for the first 20 pages and 50 cents for every page thereafter. So it's a little bit more if you wanted to follow that. But again, just remember, that's a charge to other persons or entities that you're authorized to release medical records to. So, and this slide will come up. I think there may be a duplicate a little bit later on, but are there situations when you cannot You just can't charge for the release of medical records. Well, you can't if it's an application for disability or other benefits or assistance to all these different little entities. And we're bringing this up because this is an issue that does come up. TMLT does receive questions about this. And you need to know that if you're getting an application for disability or benefits from Medicaid, Medicare, Social Security, veterans benefits, some sort of aid program, you can't charge. Okay, you can't charge that statutory rate. It's just, you just have to provide that information. Obviously, you need to provide records in an emergency situation without a charge. There may be other situations where it makes sense to provide records at the request of a patient promptly. If you have a difficult patient who wants to switch practices, typically, as a courtesy, I know this typically as a courtesy, practices don't charge each other for medical records going over to the other practice, but you shouldn't charge for any medical records going out that are related to the healthcare and treatment, or you generally shouldn't. And you also should really try to avoid charging a patient for the release of their medical records. This concept of giving the patient access to their medical records and allowing those medical records to move freely. The Office of Civil Rights really has taken the position that their preference is there's no charge to the patient. The patient doesn't incur charges for those medical records. So to the extent you can avoid any sort of charge to the patient, it's recommended that you do that. So when can a covered entity withhold healthcare records for non-payment? Well, the answer is never, unless there's a failure of either the patient or the requesting entity to pay that reasonable cost associated with the healthcare record itself being sent out. So a practice can never withhold the release of medical records because a patient failed to pay for some sort of healthcare treatment. If it's related to treatment, you can't withhold. It's just the payment of that reasonable rate for the release of medical records. Now, here's the conundrum practices will face is that what's reasonable? Well, the OCR has put out guidance that they don't like practices to charge patients for the release of their medical records. So the OCR, if there was a complaint made by the patient, they could investigate and determine that it really wasn't reasonable for the practice to try to institute a certain charge against the patient under a certain set of facts. So we got to be reasonable. We need to be practical, and practices really should err towards the side of releasing information to the patient without a charge to avoid those kinds of complaints. Those kinds of complaints end up being more expensive than what the patient would have paid in the long run anyway, both in attorney's time and in lost practice time. So again, this is the duplicate slide that we already talked about. Can a physician or a practice refuse to release healthcare information? Absolutely. Outside of the context of non-payment for the records themselves, if it's going to adversely affect the physical, mental health, or emotional health of the patient, or if the records relate to another patient or family member, then that information should not be released. So if we're going to release records which could cause a patient maybe to become suicidal, or very upset and possibly suicidal, or might adversely affect them. Another example might be a minor who becomes pregnant and the release of information related to that pregnancy to the parents might result in physical harm. Then that information, to the extent possible, should be limited or not released to the parent or guardian. Or it shouldn't be, in that situation. In the situation where the patient was suicidal, absolutely shouldn't be released unless it's absolutely can't be avoided. There's always some sort of exception here and there, but I think this goes back to professional judgment in the release of that information. Now, in terms of access and having that information released to other people, like the ability for it to go out and the free flow of healthcare information that the OCR wants, there could be a scenario where you can go into the medical record and redact a portion of that medical record related to maybe mental health or related to another person and release that record. In that instance, the practice should consider a redaction and a release of that record if it doesn't, again, adversely affect the physical, mental, or emotional health of the patient, or it doesn't release the information. So as long as the information about another individual is completely redacted, there's no way to know about that section. It might be okay to release that information. Again, case by case basis. So what should you do as a physician or a practice do if a request is denied? Well, it's really a 4-step process. You put it in writing, and you put in writing why you denied the information. It should be signed and dated. This needs to be written by the physician. Now, a draft can be written by the staff, but the physician needs to finalize, sign and date. The reason for the denial needs to be stated clearly, and it should be charted, either in the medical or the billing records, depending on which one you're not releasing. So another area that we often have questions about are business associate agreements. And a business associate agreement, it is a legally binding contract. And examples of business associates are attorneys, billers, medical record vendors, cloud storage providers, IT providers, people who perform a function on behalf of the practice who are not the actual employees of the practice and handle protected health information as part of that function. So in this case, TMLT does get a lot of questions about business associate agreements. So I'll invite Cathy to provide some input here on her perspective on business associate agreements.
I think it's interesting to note that we often have practices that we're working with for some other reason, not necessarily a cyber incident or a breach, that have not identified who their business associates are. I think the other big assumption, maybe incorrect assumption, is that it is the responsibility of the vendor to provide the covered entity a business associate agreement, because that often happens. We're talking large vendors, your EHR companies, that type of thing. Those people are used to handing a covered entity a business associate agreement and expecting them to sign it. In reality, the law requires that the covered entity be the one who gets the business associate agreement. So it's not like there's um, a an automatic assumption, or there should not be an automatic assumption that it's somebody else's job. It is the practice's responsibility. Uh, and they don't have to be updated unless the law changes or the business associate changes, because they do not have to have an end date. They don't have to be renewed.
Um, I think you and I have had instances where a lot of practices don't even have business associate agreements in place, is it? Or they haven't had it a good listing of business associates or an updated list of business associate agreements. Does that sound about right?
That's very true. And I can promise you that that's something that the OCR often will ask for in an investigation. Um, business associates can be held liable under the HIPAA rules just like a covered entity. And sometimes it's that the business associate is the one being investigated and they find out they don't have BAAs with the covered entity, and the covered entity becomes the subject of an OCR investigation. But I think this is more your area, Adrian, about is a business associate agreement an enforceable contract?
Yeah, and I think one of the key takeaways is, it is, and we we can use it, and we do see it seen as a way to risk shift for the practice. So if the business associate is the cause of say a cyber breach, there can be language within that business associate shifting risk over to them, or shifting the responsibility for the damages associated with that breach, or the notification associated with that breach. What you do want to know, what you do want to be careful of, is that if your business associate agreement is silent about who is responsible for notifying in the event of a breach by a business associate, that that obligation resides with the practice, unless it's contractually um, unless it's promised and there's an agreement for it to go back to the business associate in the business associate agreement. And even then, I think the practice has a duty and obligation to make sure the business associate does in fact notify. Um, in my mind, I like the practice always having the responsibility to notify, but the business associate being on the hook for any associated damages. That allows the practice to control how the notification is done, when it's completed, and it makes the business associate responsible for damages. You could also, in the business associate agreement, include a requirement for cybersecurity insurance, although that might be in your master services agreement. But that's another area to consider. What happens if you don't have a BAA in place? Well, you're in violation of the rules for sure. And we do see this, especially when we have breaches. We do see practices that don't have business associate agreements in place, like Cathy had mentioned. And the way we handle it is we get those business associate agreements audited and in place as soon as possible. And we try to document that with each business associate, that they were following the HIPAA rules prior to the implementation of the business associate agreement, to the extent that's true, right? We want to document that. So even though we don't have a business associate agreement in prior to the date that we entered into, we might be able to create some sort of documentation that everyone was making their best efforts to follow the HIPAA rules before it went in place. Any other thoughts on this slide, Cathy?
I think that's just the real take home message, that before you exchange any kind of data, even if it's just send me a sample of your data and let me convert it for you, or whatever the business associate's going to do with it, make sure you have that in place, even if it's pre entering into an actual contract. Get that in place, because that protects you, and that's the big thing.
There's two questions I see that relate to BAs, and before we go on, maybe we can attack those. And do business associate agreements expire? Not unless you have an expiration date within it. So they're valid, and they're valid as long as the person has that information, has control of the protected health information. And also, um, how often should you look at your business associate agreements? I would recommend at least once a year. But Cathy, what is your feeling on that?
I think that's a really good rule of thumb, because perhaps you have stopped doing business with someone and you don't want to have that business associate agreement in place any longer, or you don't want it on your active list. So I think reviewing them annually is a great idea.
And then there's a question, does TMLT have sample BAAs available?
They certainly can reach out to us at cyber@tmlt.org, and we can provide that, or our risk management department, either one.
Okay.
Looks like we have about 15 minutes left. We've got a couple of other topics I think we want to try to cover. So, Adrian, I'll let you move on.
Okay. Information blocking is a term that I think you're going to increasingly hear more about. And there's the 21st Century Cures Act, which talks about this. This is really one of the efforts to stop blocking that restricts a patient's access to healthcare, to their healthcare record, and when it's not in the best interest of the patient. An example of this may be when a practice has a problem with an EHR vendor. This is one of the scenarios, and your EHR vendor isn't releasing the data to you or your patient, or you can't access it because of a dispute, whether it's financial or otherwise. This act is intended to start covering those scenarios and also apply to those business partners that we have, so that it's important for your business partners to understand their obligations under this act. Can your practice get in trouble for information blocking? The takeaway is yes, if you're knowingly taking actions that interfere with the exchange, access, and use of electronic health information. So,
Adrian, you may
yes.
want to share your video again.
Oh, I'm
We've
sorry.
lost your video feed.
So as a practice deals with security issues affecting their protected health information, one of the considerations now is, have I put in place so much security that I have restricted access to a patient's ability to access and obtain their medical records in a timely fashion? So that's a very general, simplified example of this kind of concept that the 21st Century Cures Act is trying to put in place. There are exceptions, right? So we have an exception that before you release medical records, you have to have a written authorization. That's as much for privacy as it is for security. You have a security exception, which allows you to protect information in the manner that is prescribed, both that the government kind of recommends, but that the practice finds feasible and reasonable, and meets the guides set forth by in the HIPAA rules and in the guidance from the OCR. There's also an infeasibility exception, or a preventing harm exception, not to release records to a patient, or limiting the release of records to a patient. So this is a developing area that I think you're going to hear a lot more about in the coming months and year. And they're really working on kind of trying to work out and flesh out the nuances of it. But just be aware that you want to be careful not to limit the access to the patient. So remember, if you're charging your patient and you're restricting their access to medical records, and maybe they can't afford to pay your charge because their record is so voluminous, that could be an issue that comes and falls under this act. So I think we're going to start getting examples. They're fleshing this out, and I think we'll start getting examples of issues coming up next year, or potential violations where they provide more guidance on this issue. So where should your practice start? You should look at your agreements. You need to consider how your patients access and use your information, and then you're going to need to update your policies and procedures to be compliant with this act. Check with your vendors, define your reasonableness standard, and train your staff. And if you have questions, legal questions related to it, then you have resources. You don't always have to go to a lawyer when for legal questions, it's recommended to go to a lawyer, but you don't always have to get that information from the lawyer. TMLT has great resources. TMA has great resources. So just educating and starting there. And then when you have specific questions, maybe hire a lawyer if you need to have some specific information researched and vetted for you. Another question we get a lot is, how do I evaluate my IT vendor? I will tell you, we're evaluating our IT vendor, but you really need to know what are your IT needs and goals internally. You need to look at the applicable laws that apply to your practice. You'll want to do a risk assessment of your current system to understand where you need to go and how you need to get HIPAA healthy and how you need to protect information. And then you really need to start vetting third-party vendors. And it's just not easy. It's time consuming. But I would recommend you try to identify 3 vendors who you think are competent and capable vendors. And then you interview them and you ask hard questions and you see the information that they're providing you with. Some of the keys, if they know what the HIPAA rules are, if they know what a business associate agreement, if they have a CISO on staff or a director of technology, if they have people who have credentials with HIPAA or computer information systems, those are providers who you want to talk to, and you should take comfort in knowing that they should have a pretty good grasp on security. But ask them the hard questions. Ask them what's the standard for protecting this kind of information? See if it makes sense. Dual factor authentication is pretty much standard these days. So if something doesn't jive and you don't like your interviews with those 3, keep going. Keep interviewing until you find the vendor that you can identify that makes the most sense for you, but actually knows what they're doing. Because as we're going to see here in just a second, your choice of vendor can make a big difference in whether a ransom attack is successful or not. So do practices really need to worry about IT security? Absolutely. We still are, practices, businesses everywhere are still facing ransom attacks. A ransom attack is not necessarily just them locking up your system, although that can be some of the most dangerous, but it's also them getting into your system and potentially taking information out of it. So there's been some pretty steady increase in payments of ransom, and you can see that this chart is on an upward trajectory. Even though it's going up and down, it's still headed up, and I would expect that ransom demands and payments will still steadily decrease in the coming years. Healthcare in the 4th quarter of last year, about 13% reported to this particular source for hackings or ransomware attacks. It decreased in the 1st quarter to 7.9%. I've been following this particular blog for a long time. They have very good reporting. Generally, healthcare is about 10% of the industries affected by ransomware. So a sizable chunk, and one of the favorite targets of threat actors out there. The attack vectors, and this is where we talk about it. So we see this, which was very high over here. It's RDP compromise, and we see it decreasing. This has been through education of IT professionals and how to secure systems due to attacks. So when we talk about your IT professional, how educated are they? How knowledgeable are they on IT attacks? Because the threat actor who attacks your system is going to be an expert in getting into systems. So you really need to have an expert or someone who's very knowledgeable protecting your system. It's no longer just to have your help desk IT guy who knows a little bit about security too. One IT vendor had a very good comment to me recently, and they said, practices and businesses really need to think of IT as 2 separate things. You have your IT hardware and software and systems, and then you have your security. And you need to budget and segregate for the 2 and treat them as separate things. So we really need to have an IT expert on security. Some of these IT vendors, they have in-house, which I said, a CISO, a Chief Information Security Officer, who can provide expertise and guidance. And how they handle that is fractionally. If you have you can just hire them on an hourly basis to perform work and address those security issues, but they don't have to be a full-time expert for you for the year, right? They're going to provide fractional support throughout the year, and then you just pay the cost of their invoice. So to prepare, that means you really need to budget time, money, and resources. Yeah, you need to understand and implement specific policies and procedures, hire a competent IT vendor, assess your systems, back to safeguards, review and implement your safeguards, have a plan with how you're going to address, your risks. You have low, medium, and high risk. How are we going to get the high risk to your practice down to low? Train your employees, because if we go back here, this is email phishing, which is an employee clicking on that email, is traditionally one of the best ways for a threat actor to get into your system. So employee training is very important. We do quarterly training in my firm. Some people do monthly training. I've heard of some firms doing that. Check your insurance coverage. Make sure you have adequate and sufficient insurance coverage for a cyber incident, and then have an emergency response plan. That includes making sure your backups are offsite and segregated and removed from your system and regularly backed up. An emergency contact checklist, which probably should include your insurance company, and a plan if you go down. So that's actually the last slide in the presentation. We may have a few. It looks like we have 2 minutes if we wanted to try to tackle one or two of those questions. I see, with regard to the release of medical records to a deceased patient, if the family doesn't go to probate, could they get information? Well, yeah, absolutely. If the person's a person, there is a statutory order of persons listed in the probate code if a person does not have a will. So those would be people authorized to take over that person's or to deal with that person's estate. Typically, they'll go to the court, but sometimes in a small state, it's just the spouse dealing with it. And 9 times out of 10, the spouse probably already is going to be listed in your consents. So you really want to make sure your consents are good when the patient checks in. And then when you probably want to update that consent and authorization form yearly with your patients, so you know who you can release information to. If someone walks in with a will, the best way is to know that they're the personal representative and they are the testator, or the executive of the estate. But there may be an instance where they're not going to probate it, and they have a copy of the will. They're the executor. It's pretty obvious and apparent from the circumstances that information can be released. So there could be situations where you don't have the letters testamentary provided to you. But I'd contact TMLT and possibly an attorney about those unique situations.
So this question about if a patient disputes their credit card charges and the credit card company requests proof of services rendered, how should this be handled? This is actually a question that I have dealt with a couple of times. The interesting thing is you really can't release records to that credit card company unless you get the consent of the patient. This is one of those authorization needed situations. And so if you have this situation, obviously, if the patient wants that credit card charge removed, they should give you sign the authorization. If not, the best you can do is to just tell the credit card company that they may need to be the ones to ask the patient for an authorization for the records, because it depends on the situation. Everyone is different, but you can't just give those to a credit card company. Do you have anything on that, Adrian?
No, I think you just have to go back and ask for that authorization, before releasing. I agree with you.
And there's one last question, if we can get to it real quickly, about, is there any such thing as minimum necessary when aging out teens to an adult practice? Can I send mental health information? So that one's kind of a double-edged sword. First of all, there's minimum necessary, um, but then also the mental health side of the question.
Yeah. I mean, whenever I see mental health, you want to be very careful not to send mental records without an authorization. Generally, is what always pops into my mind. How about you, Cathy, with that mental health issue?
Absolutely. There's definitely concerns that come to mind. I know that at the federal level, they're working on rules to bring the mental health records release more in line with HIPAA, because they have not lined up very well. Um, I was at a meeting a couple of months ago where that was being discussed, but that still sounds like it's months away. So stay tuned. We'll have a webinar on it.
I think the first part of the question, the minimum necessary, if I'm reading that right, and I'm not 100% sure I understand it completely, but I mean, one solution, as teens age to adults and parents are involved in the healthcare and treatment of their teens on every visit. Myself or my wife go to a visit with our teens, so we're involved. There comes a point where maybe that conversation needs to be had with the group, with whether how that relationship continues, or is it appropriate at this time for the teen just to have, or the adult now just to be in charge of their own healthcare and whatnot. So there's an open conversation about that. And then this goes back to, well, the consents, if you're getting consents updated on a yearly basis, if that adult says, I don't want my parent to be involved in my healthcare anymore, I'm 18, then you have to honor the request of the patient. And that's just the way it is, unless they change their mind and you get it in writing.
Adrian, thank you very much for your time. Lots of time went into the preparation for today as well as the presentation, and we so appreciate your perspective when it comes to helping practices out. Uh, I would just remind everyone that if you do have questions that we didn't get to, or if you have questions uh, later, cyber@tmlt.org is the email address to send them to. And you will receive an CME evaluation link in the email that you'll have tomorrow morning in your inbox, and you'll get your CME certificates in about 10 days. Thanks again, Adrian, and
Thank you.
everyone. Stay in out of the heat, and